The next case is State versus Bennett. I assume both sides are ready. Just switch seats.
That's right.
I love it. Anyway, so the next case is State of Ohio versus Bennett, and each side will have 15 minutes, and the state now, as the appellant, will have 5 minutes to reserve for rebuttal if you so choose. The same rules apply: no mention of victims' names, no mention of children's names. Anybody that is not a defendant in the case should be referred to by initials or by their status. So thank you much for following these rules, and you need to stand behind the podium, and we are recording. I know you've heard this before, and we are recording, and please stand behind the podium and keep your voice up. Okay, we're ready to proceed if you are.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. I am Spencer Lepwitz on behalf of the state of Ohio through the Lorain County Prosecutor's Office. We are here today because the trial court erred in determining both the facts surrounding their decision to suppress evidence against Mr. Bennett and the rationale surrounding the decision to suppress evidence against Mr. Bennett. There was, at the suppression hearing, significant discourse between the officer who testified, Officer Sergeant Gosluski, and the defendant regarding, I want to make this clear, regarding only whether or not Mr. Bennett was at any point actually blocked into his parking space. To go back a little bit, at 2 in the morning in Sheffield Lake, so these facts are because they're important for the court's determination. Mr. Bennett observed a white pickup truck with a red snowplow drop, or not Mr. Bennett, Officer Gosluski observed a white pickup truck with a red snowplow drop off 2 individuals in front of a self-storage facility early in the morning on a cold January night. Those 2 individuals were stopped initially by Officer Gosluski, and then 2 other officers from the Sheffield Lake, Officers Fisher and Ebert, followed up with those 2 individuals, where they were found to have in their possession multiple tools which could be used to break into a self-storage facility. They did not have the code in the facility. They were arrested and charged with possession of criminal tools and attempted breaking and entering. 2 hours later, while Officer Gosluski is still on patrol, he sees a white pickup truck with a red snowplow parked backed into a parking space in an apartment complex at 4 in the morning with a single occupant in the cab, and the car was turned off. He observed the car for about 10 minutes. No one entered or exited the vehicle. Mr. Officer Gosluski then approached the vehicle, parked in his car in a manner to partially block, which is determined by the trial court, to partially block the pickup truck in the space, and then approached and inquired. He did not activate his emergency lights. He did not shine a spotlight on Mr. Bennett. He took no other action that could be conveyed to, display the authority of the state.
Of course, he could have parked anywhere.
He could have parked anywhere.
And he did say that in his testimony, didn't he, that he wanted to make it inconvenient.
Yes, Your Honor, he did.
For the defendant to leave.
Completely correct, absolutely, he did say that, Your Honor. He also stated on cross-examination that he was not blocking Mr. Bennett in a way that he could not leave.
But he said it would be very difficult.
Yes.
I'm sorry, go ahead.
No, you're right. The law does not require that he be completely blocked, does it?
Well, the law requires that he be detained, and the Ohio case law is not clear on this subject, but the federal case law has extensively gone into history, or gone into the different permutations of how an officer may or may not block an individual. I didn't reserve time, 5 minutes for rebuttal, please, Your Honor. I did not may or not block an individual. In 2009, 2011, the 6th Circuit, when considering the actions of the same CMHA officer, which I found to be a little funny, determined that when a car or when an officer completely blocks so that the person who is being inquired about or asked questions cannot leave their space where they are parked, that indeed is a detention and indeed does require reasonable articulable suspicion. On the other end of the spectrum, they determined that when an officer parked 12 feet away from the person who they wanted to investigate, in a car wash where the defendant or suspect or subject could either pull forward and away or back up and leave the property in that manner, when that was the fact pattern, it was a voluntary stop at that point and did not require reasonable articulable
So
suspicion.
is that your argument here, that it was a voluntary stop?
My argument here is that this court should follow the determination of the Sixth Circuit in U.S. v. Williams in 2013, which I think is the most analogous to what is happening in this fact pattern, where at that point the Sixth Circuit determined that when an officer partially blocked, he pulled his cruiser up in such a way that it was partially blocking, would have made it difficult for the subject to maneuver out of the alleyway where he was stopped. At that point, if that was the only factor for determining whether or not this person was detained or whether or not the officer needed some form of reasonable articulable suspicion or probable cause, had the position of the car been the only factor, then the hypothetical egress, I'm quoting here from 525 Federal Appendix 330, 333, had the hypothetical egress would have doomed the defendant's case. The potential to leave the interaction without.
In that case, did the officer say that he, what was it he said here? He said, make it inconvenient?
The officer did not say that, or at least the trial.
Was there some sort of testimony to that effect, or?
There was not testimony to that effect at that point, Judge. The only testimony, or the only finding of fact based on the actual position of the car and any contextual of that was simply that it was partially blocking the alleyway, but that the suspect could have likely been able to maneuver away.
Well, the officer here though also testified that all he had to do, the defendant, all he had to do was ask him to move the car.
Yes.
Isn't that analogous to putting somebody in a room with a locked door and say, all you have to do is just ask me to open the door?
I don't think that's analogous to that here at Judge Carr. I think it's more analogous to say if I was trying to leave this room and there was an officer in the vestibule, I could ask him to please step aside, but he might be already closer and I could sneak by to the right. Whether I would ask somebody to slightly move out of the way doesn't mean that I am therefore blocked to move out of the way and stuck in the room that I was found in.
But it sounds like the officer was saying he had to obtain permission to leave, because he said, if he had asked me.
Well, I think, Judge Carr, there's two problems with that, right? I think the first problem with that is that the officer said it was to make it inconvenient, and that in conversation on cross-examination, the officer explicitly said, was asked, you're blocking him in, can we agree on that? And the officer explicitly said, no. And I think the second problem is that the trial court didn't make a determination on whether or not Mr. Bennett could leave. The trial court said he was partially blocked. I'm not quite certain what partially blocked means. I'm not quite certain if it means he could have left, or if he could have not, or if he was in fact stuck in there in such a way that the officer would have needed to move his car. What I do think it means.
It did seem, I'm sorry, I didn't mean to interrupt you. It does seem that it was significant to the court, because the trial court quotes the fact that the officer said, if he'd asked me to move, I would have moved, so he could have left.
I agree, but the trial court, again, based on this journal entry, says partially blocked, but doesn't find how blocked. And I think that's significant because, as I said earlier, there was no other factor relating to states that show authority by the officer. And I think what ultimately means is that the trial court didn't find enough facts to enable effective appellate review. And I think that for that reason, it needs to be sent back or remanded to the trial court so it can make those findings of fact. However, we also take issue with the standard that the trial court used. The trial court used a probable cause standard. That wasn't the correct standard for the court to apply. The officer wasn't interacting with Mr. Bennett in a way that required the use of probable cause. If Mr. Bennett was detained, and again, we do not say that he was at that point, but if he was detained, then what he needed was reasonable articulable suspicion that a crime had occurred or was occurring. I would point you, and this is why we're in facts, I point you to the facts that we had a white pickup truck with a red snowplow drop off two individuals outside of a self-storage facility. And then we have that same, or at least what appears to be that same truck, 2 hours later, in the same city, sitting turned off at 4 a.m. on a cold January night in a parking lot. I think that gives rise for an officer to say, I don't know what this is, this looks suspicious, I had an interaction earlier tonight involving a similar looking pickup truck. And I think it's analogous to the State v. Figueroa case out of this district, it's 2010 Ohio 189, you know, where the officer saw a two-toned GMC Suburban with a dent in the door that could have been involved in the possible theft of a credit card, but wasn't able to inquire about that car until 8 days after they originally saw it, after the complaint was originally made, after they originally became suspicious of that car. That 8-day delay, in that case, did not taint, did not quell, did not give this court a reason to suppress any evidence gained from the interaction between the officer and the defendant, Figueroa. State submits that that's analogous here. There wasn't a delay. Like in Figueroa, the officer saw, like in Figueroa, there was no crime the officer observed the car or the car's driver making at the time of the stop. Regardless, based on past information, you know, based on complaints and investigation, they were able to, you know, inquire of the car and find out ultimately that this person had indeed stolen the credit card and used it at a Taco Bell drive-thru.
But counsel, at least in that case, didn't the officer who made the stop know that a crime had been committed? But in this case, the officer that detained or did not detain did not know that, because he wasn't investigating what happened at the self-storage, did not know that a crime had been committed.
Well, I see your point, Judge. I would, you know, to that I would say that the officer testified, you know, that he alerted Officers Fisher and Ebert that he was approaching this car in the parking lot. I think that lends itself to the idea that he was aware that there had been an investigation regarding a potential crime earlier in the night. I think it lends itself to the belief that he was saying that this car was related to the investigation that happened earlier in the night. I think it's not there to say that they were investigating the same potential crime. And again, it's not that a crime had occurred, it's that a crime was likely to have occurred or was likely to occur in the future.
Counsel, you are into your rebuttal time.
Well, I
You
appreciate
can keep
that.
arguing, but I just want to alert you to that.
No, I appreciate the warning, Judge. I think I'll save the rest of the time for rebuttal. Simply say, you know, for those two reasons, we ask that this court, you know, remand the issue back to the trial court for either further finding the fact or find that there was sufficient reasonable suspicion as the facts are before it, and overturn the decision of the trial court.
Thank you.
Good morning, Your Honors. Kenneth Blue on behalf of the appellee. At the outset, I think it's fair to note, I think the trial court did use the words probable cause, and perhaps the reasonable suspicion standard was the proper words. However, I did raise that issue in my original motion to suppress. I think the trial court was correct in granting the motion to suppress. It's kind of a curious set of facts. Is this a Terry stop? The person sitting in a lawfully parked car with the motor off? Is that a Terry stop or is it a vehicle stop? It's kind of a hybrid, I think, the way I see it. I mean, the officer approached somebody lawfully on the street, in a parking lot, whatever you want to call it. He's in a vehicle, it's not running, it's not illegally parked. Obviously, clearly the officer parked his car in such a way that, as you all already pointed out, partially blocked. So I don't think it's really in dispute that there's a detention, there's an interrogation. It wasn't real clear because the prosecutor who called the witness didn't ask a lot of questions about that. This is the only witness the state called, and these are the questions that were asked of the witness.
So counsel, let's back up a little bit in regard to the standard that the court used. So you agree that the court should not have used the probable cause standard?
I do.
Okay. So, but you're asking us to not reverse on that basis for the trial court to look at it again. You're asking us to determine that it didn't matter which standard it was.
I think the court, I suppose I could ask the court to do what is a de novo review of the facts and evidence and apply the reasonable suspicion standard, the Terry stop standard, the stop of a vehicle standard. I think it's essentially the same. Is there reasonable articulable evidence that criminal activity is afoot? And I think it's clear from all the answers this witness gave, no. He couldn't identify one reasonable articulable suspicion. Even going back to the self-store unit, what crime occurred there? Two people walked up to a gate, couldn't gain entry and left. There's no testimony that they tried to jimmy the lock. There's no testimony that they tried to break in. They were merely observed to go to the gate for a moment, turn around and start walking down the sidewalk. And then they were detained by the other two officers. And I think it's worth noting, they weren't charged, those other two individuals weren't charged with breaking in. They were charged for something that was in the one guy's backpack, and the guy had a warrant. So that's why those two apparently that's the crime they allegedly committed. I don't know whether they filed to suppress or not. It seemed to me, based on the testimony I heard, that the two individuals stopped walking down the sidewalk, probably had a reasonable argument that their rights were violated in being approached under these circumstances. But be that as it may, my client wasn't even there. All he did was drop two people off and drive away. And the officer could not articulate one crime, one traffic violation, based on what he saw this white truck with a red snowplow do. Didn't even get the plate. That vehicle left. The moment just dropped two passengers off and left the scene. No evidence, indication that that person who dropped those people off had any involvement in any crime. 2 hours later, he sees a similar vehicle lawfully parked, and his suspicions raised. He watches for 10 minutes, and what does he see? Nothing. And I think I asked him multiple times, what crime did you see? What criminal activity did you see? Can you articulate one violation of traffic law, one violation of the Ohio Revised Code that the person driving that snowplow parked in the parking lot lawfully had done? He couldn't articulate anything. He just wanted to inquire.
Well, when you say articulate a crime, you don't really have to name the crime. You just have to have reasonable suspicion that crime may be committed in the near future.
Right. Criminal activity, I think they like
Criminal
activity may be afoot, I think is the often used phrase. Well, what criminal activity may be afoot? He couldn't articulate anything. But he did acknowledge, I wanted to inquire. I moved my vehicle from across the street, parked it, partially blocked him, and I think you correctly pointed out, it's on page 36 of the transcript, you parked your vehicle in such a way that he couldn't leave. Would you agree? It would have been difficult for him to leave because you blocked him in his parking spot, correct? Not completely. To make it an inconvenience, all he had to do was ask me to move it, and I would have moved it. Well, that's a detention. You can.
Counsel, let me ask you this. What if he had pulled in beside the truck and then gone over and started asking the driver some questions?
I think it's more than a Terry stop.
I can't hear you.
I think it's more like a Terry stop at that point. Yeah,
If he just parked his car beside of him and didn't prevent him from leaving and walked over to the driver's side and said, hey, can I ask you a couple questions?
That's not what happened though.
I understand. I'm trying to figure out what your approach would be on that.
Well, my approach is these are the facts. I think we have to apply the law.
Okay, so in other words, you would know that that's not a problem.
To make an inquiry, correct, just in your example, that's not a problem. Please can ask questions like that, sure. But that isn't what happened.
So the main thing here is the fact that he pulled his cruiser in front of the car
He prevented him from leaving.
or the truck.
He prevented him from leaving. The only way he could have left by the officer's own admission was, all he had to do was ask me, and then I would have had to have moved my vehicle, which would allow him to. So, I mean, that clearly is a detention at that point. The only thing I just point out, I did note there's some things in the appellant's brief that are not in evidence. I would certainly trust the court would not consider those things, some footnotes and something on page 4. Facts certainly not in evidence, and I would ask the court not to take those into account.
And we definitely don't look at anything that's not.
I know you do. It's one of those things, I don't know if I have to say it.
No,
but
that's fine, we
I guess I'll
appreciate it.
say
I just like to reassure, and then that reminds council too, not to do it, because we're not gonna look at it anyway.
I appreciate it. Thank you.
And you do have 3 minutes and 18 seconds left if you want to use it.
Thank you, Your Honor. I want to start by clearing up maybe an incorrect or a mistake made by Mr. Liu. The other 2 defendants were charged with the same violations that Mr. Bennett was, which is 2911.13b, breaking and entering, and 2923.24a, possession of criminal tools.
And is that in the record?
Certainly hope so, Judge.
Well, you don't talk to us about things that's not in the record, you have to make sure first.
Regardless, and I appreciate that, and I would say regardless of whether or not that in fact is in the record, what we do know is that Officer Goslowski did inform the other 2 officers who were investigating the incident happening previously in the night more thoroughly than he was, that he found what he thought to be the car that dropped off those 2 individuals. I would point out that the own site that Mr. Liu referenced on page 36, the officer says, not completely. You blocked him in, not completely. There wasn't a finding of fact that would enable this court to determine whether or not Mr. Bennett could leave. Without that finding of fact, I don't know how this court can say whether it was a detention or whether it was a voluntary stop. It would require this court to make inferences that I don't think it would be appropriate at this level of appellate review, based on the dispute in the record and the trial court's failure to actually come to a decision or come to a conclusion on what those facts were on that night. This court isn't engaged in no review at this point. This is a mixed review of fact and law, and it's the trial court's responsibility to articulate facts that enable appellate review, and the trial court didn't do that in this situation. Because the trial court failed to make those facts, the most appropriate action for this court to take is to remand it back down to the trial court to make those determinations. At that point, the state would certainly also appreciate ruling from the trial court that it is improper to apply a probable cause standard to this circumstance. It wasn't a traffic stop. It wasn't necessary for probable cause to exist. This was basically a officer approaching an individual. Well, the fact that they were in cars at that point is I think for this set of circumstances irrelevant, because there was no, as Mr. pointed out, traffic violation that is alleged. He approached, he inquired. Under Florida v. Bostock, that is allowable for an officer to approach and inquire a citizen on a voluntary basis. For those reasons, the state would ask this court reverse the decision of the trial court and remand for further findings of fact. Thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as you can look on the Supreme Court website. Thank you very much, gentlemen.
Thank you, Your Honor.